Hello students, welcome to AKS. Today we will deal with the current affairs as part of polity and governance for the third week of August. Now let us look into this article stating the hard realities of India's fast track courts. What is the context of this article? The Ministry of Women and Child Development informed the Rajya Sabha that the government has proposed to set up 1023 fast track courts so as to clear the cases under the Protection of Children from Sexual Offences Act. Okay, so this was stated following the Supreme Court judgment, which asked the central government to constitute fast track courts in such districts across the country which has over 100 cases of child abuse and sexual assault pending trial under the POCSO Act within 60 days. In this backdrop, the article highlights the decline of fast track courts in handling special cases and mentions that by merely increasing the number of judges in such courts will not solve the actual problem persisting in these fast track courts. So, what are the issues plaguing the functioning of fast track courts? The government is spending large sum of money to create additional posts, but little is being done to identify and address the prevalent systemic issues. The author explains that fast track courts have been in prevalence since 2000, but it has not effectively solved the pendency of cases. So, the pendency of cases is still high in spite of functioning of fast track courts. As per the reports of the Ministry of Law and Justice, at the end of March, there were 581 FTCs operationalizing in the country, with approximately 5.9 lakh pending cases, where Uttar Pradesh having the most number of cases. However, 56% of the states and union territories, including Karnataka, Madhya Pradesh, and Gujarat, had no fast track courts. So it is a hard reality that still in India, about 56% of the states and union territories do not have fast track courts. Also, rupees 870 crore was released by the center between the year 2000 to 2001 and 2010 to 2011 towards the fast track courts. Also, in a survey of fast track courts conducted by the National Law University Delhi, it was observed that there is a huge variation in the kind of cases handled by these courts across states. So, some states primarily allocated cases of rape and sexual offences to these fast track courts, whereas other states allocated other matters as well. So, there is also a variation in which these different states have used the fast track courts. Several fast track courts lack technological resources to conduct audio and visual recordings of the victims, and many of them did not have regular staff. So, let us look into the status of fast track courts in India. The 11th Finance Commission had recommended a scheme for establishment of 1734 fast track courts for the expeditious disposal of cases pending in the lower courts. These courts were to be established by the state governments in consultation with the respective high courts. An average of 5 fast track courts were to be established. The judges for these fast track courts were appointed on an ad hoc basis. Also, the judges were selected by the high courts of the respective states. So, this is how the implementation of the fast track courts has been done in India so that speedy delivery of justice was to be achieved. But, however, in reality, it has not been that effective. So, now let us look into some of the solutions to address the systemic issues plaguing Indian judiciary. Number one, increasing the number of judges. The Law Commission in 1987 had recommended that India should raise the number of judges to 50 for every million population. Number two is the filling up of vacancies. The administrative hurdles and unwillingness of the state governments is the cause of increase in vacancies. The respective state governments must work towards reducing these vacancies. Next, rationalization of judicial structures. Fast track courts and special courts are administered under the different judicial bodies with little coordination or uniformity among them. Therefore, a lead agency is to be established by the central and state governments to review the functioning of courts in a systematic and streamlined manner. The fourth important point is capacity building and improving the infrastructure of the courts. The training of the staff as per the demand of fast track courts is the need of the hour. The fast track courts must be provided with adequate infrastructure so as to provide justice in a fair way and reduce the pendency of the cases, which is a fundamental objective. Next, a holistic approach of fast tracking the investigation to complement the fast track courts and providing a special procedure different from the procedure followed by the regular courts is also required so as the fast track courts meet their objectives. Next, Consumer Protection Bill gets the Rajya Sabha green light. So, what is the definition of consumer as per the Consumer Protection Bill? A consumer is defined as a person who buys any good or avails any service for a consideration. So, it does not include a person who obtains a good for resale or a good or service for commercial purpose. Also, it covers transactions through all modes, including offline and online through electronic means, teleshopping, multi level marketing, or direct selling. So, this is a basic definition of who constitutes a consumer so that the protections under the Consumer Protection Bill can be availed by such person. What are the rights of consumers as per this bill? Number one, to be protected against marketing of goods and services which are hazardous to life and property. Two, to be informed of the quality, quantity, potency, purity, standard, and price of goods and services. Number three is to be assured of access to a variety of goods and services at competitive prices. Four is to seek redressal against unfair and restrictive trade practices. So, what are the key features of the Consumer Protection Bill? Number one, the Central Consumer Protection Authority. The central government will set up the Central Consumer Protection Authority to promote, protect, and enforce the rights of consumers. Okay. It will also regulate matters related to violation of consumer rights. Unfair trade practices and misleading advertisements has also been covered as per the Consumer Protection Authority. The Central Consumer Protection Authority will have an investigation wing headed by the Director General, which may conduct inquiry or investigations into such violations. The CCPA will carry out the following functions, including inquiring into the violation of consumer rights, investigation and launching prosecution at the appropriate forum, passing orders to recall goods or withdraw services that are hazardous, reimbursement of the price paid, and discontinuation of unfair trade practices as defined in the bill. Also, issuing directions to the concerned trader, manufacturer, endorser, advertiser, publisher to either discontinue a false or misleading advertisement or modifying it. Then, imposing penalties is also one of the function. Also, issuing safety notices to the consumers against unsafe goods and services is also one of the chief function of the CCPA. So, what are the penalties for misleading advertisements? This is something very important in today's scenario. The CCPA may impose a penalty on a manufacturer or an endorser for up to rupees 10 lakh and an imprisonment of up to 2 years for a false or misleading advertisement. In case of a subsequent offence, the fine may extend up to rupees 50 lakh and imprisonment of up to 5 years. Next, how does the Consumer Protection Bill deal with the misleading endorsements by the celebrities? The endorser can be levied with a penalty of up to rupees 10 lakhs by the CCPA for false and misleading advertisements. The CCPA can also prohibit the endorser of a misleading advertisement from endorsing that particular product or service for a period of up to 1 year, which may extend to up to 3 years for a subsequent offense. However, the endorser will not be liable if he has exercised due diligence to verify the veracity of the claims made in the advertisement regarding the product or service being endorsed by him. Consumer Disputes Redressal Commission. So, these consumer disputes redressal commissions are to be set up at the district level, state level, and the national level. A consumer can file a complaint with the CDRCs in relation to unfair or restrictive trade practices, defective goods or services, overcharging or deceptive charging, and the offering of goods or services for sale which may be hazardous to life and safety. Now, let us look into the jurisdictions of the different redressal commissions. So, if the value of goods and services is below rupees 1 crore, then the District Consumer Dispute Resolution Commission will handle this. If the value of goods and services is below 10 crore, then the state CDRC will handle. If the value of goods and services is over 10 crore, then the national CDRC will handle. The complaints against an unfair contract can be filed with only the state and national commissions. Appeals from a district CDRC will be heard by the state CDRC. Appeals from the state CDRC will be heard by the national CDRC, and the final appeal will lie before the Supreme Court. So this is the hierarchy of the different dispute resolution commissions. Okay. Next, the new facts on the ground for Kashmir. What is the context? After the scrapping of the special status to Jammu and Kashmir and the decision to reorganize the state into two union territories, this news article, analyzes the implications of these constitutional changes. What are the negative implications? First, let us look into it. So, number one, terrorism can increase in the coming days. This is because historically, any spike in disaffection in Jammu and Kashmir has facilitated a misadventure by Pakistan. For instance, the maximum dilution of Article 370 took place in the 1960s, including changes concerning the nomenclature of the head of the state, and this was followed by the infamous Operation Gibraltar by Pakistani President Ayub Khan in August 1965. Next, success of counter-terrorism depends largely on ground level intelligence and not merely on the changes in the administrative setup. So, India has also bifurcated the state and created a union territory of Ladakh similar to what Pakistan did with Gilgit and Baltistan regions by a separate province in the year 2009. Also, after stripping Jammu and Kashmir of its special status, India cannot claim moral high ground anymore by pointing out, unlike Pakistan, it kept integrity of the state intact. Okay, so these are the various negative implications of the government decision. Also, the center needs to assure the Shia community of Kargil that their interests would be safeguarded in the new Buddhist dominated Union territory of Ladakh. India would not want to create another zone of disaffection in a strategically important border region of the state where it has already faced Pakistani aggression once. Next, another concern is related to the polarization of the state further. In the absence of any institutional mechanism to address regional and ethnic aspirations, polarization has continued to increase among different regions, often taking a communal turn. The present decision might polarize the state even further along the regional and religious lines. The claim of widespread poverty in the state, cited as one of the justifications for the decision, is not backed by facts. Only 10.35% of the state's population lives below the poverty line compared to the national average of 21.92%. The bifurcation of Jammu and Kashmir may trigger demands for further division of the state, which, unless they are categorically rejected, could trigger a long period of instability and turbulence. Finally, the return of Kashmiri Pandits is unlikely as the security environment in the valley is currently not conducive for them to go back. Next, Madhya Pradesh returns over 25% of the target under the PMAY. What is the context? The Madhya Pradesh government has surrendered more than a quarter of its allotted Pradhan Mantri Awas Yojana Grameen houses for this financial year, giving up 2.3 lakh out of the total 8.32 lakh houses allotted. This is the first time any state has done so, according to senior officials from the Union Rural Development Ministry, which administers the scheme. So please remember that the Union Rural Development Ministry administers the Pradhan Mantri Awas Yojana Grameen. So what is the detail? Let us look into the details of the Pradhan Mantri Awas Yojana Grameen scheme. This scheme aims at providing a Pakka house with basic amenities to all households which do not have a house and those households which are living in kacha and dilapidated houses. The unit assistance given to the beneficiaries under the program is rupees 1,20,000 in plain areas and rupees 1,30,000 in hilly or difficult areas, or integrated action plan for scheduled tribal and skid backward districts. The cost of unit assistance is to be shared between the central and state governments in the ratio of 60 is to 40 in plain areas and 90 is to 10 for northeastern and Himalayan states. The beneficiary would be facilitated to avail a loan of up to Rs 70,000 for construction of the house, which is optional in nature. The minimum size of the house has been stipulated to be 25 square meters with a hygienic cooking space. Further, the beneficiary is entitled to 90 days of unskilled labor from the Mahatma Gandhi National Rural Employment Guarantee Act, which is 95 days in case of hilly areas. Also, the program implementation and monitoring is to be carried out through an end-to-end e-governance model using Awas Soft and Awas app. Okay, so that is about the Pradhan Mantri Awas Yojana Gramin scheme. Thank you. Have a good day.